All right. Settle down, you magnificent, soon-to-be jurisprudence Jedis. Welcome back to Bar Prep and Chill.
The safe space for Civ Pro survival.
Exactly.
Yeah.
The only place where wrestling with civil procedure hopefully won't leave you needing actual medical attention. I'm your host, ready to, drag you through the fun parts of federal court power.
And I'm here to maybe make that dragging feel a bit more like a gentle glide, hopefully, with fewer screams.
We can hope. Okay, listen up, people. This is Mission Control for Operation Conquer the MBE. You're tuned into episode 1 of a crucial three-part deep dive into our least favorite friend, civil procedure.
Deep breaths, everyone.
Yeah, seriously. Today, we're hitting the big three, the unholy trinity: subject matter jurisdiction, personal jurisdiction, and venue. So, buckle up.
These are really the foundations. If you can get these down, the rest of Civ Pro starts to make, well, maybe a tiny bit more sense.
Huh? Slightly. Slightly is definitely the word. But hey, baby steps, right? Our goal here is, look, it's simple. We want to make these topics, which are notoriously dry, actually stick in your brain.
Yeah.
Like cheap ramen.
Memorable, if nothing else.
Right. Maybe get a few laughs with some, grown-up jokes, and definitely give you the inside track for those delightful MBE questions. So yeah, put the casebook down for a minute, maybe grab a stress ball, whatever works. Get comfy.
'Cause it's time to.
Lay back, listen, and learn.
Let's do it. Subject matter jurisdiction, SMJ. Where do we even start?
Okay, so SMJ, at its core, it's all about whether the federal court has the authority, the actual power, to hear a particular type of case.
Right, not just any case.
Exactly. Think of federal courts like a really exclusive club. They have rules about who gets in. They have limited jurisdiction, unlike state courts, which can generally hear almost anything. It's about federalism, that balance between state and federal power. Okay, so it's like the bouncer at Club Fed. They're checking IDs. Is this lawsuit federal enough for us? Your neighbor's loud parrot? Probably not going to cut it.
Unless that parrot is somehow violating a federal treaty on migratory birds while singing copyrighted songs, then maybe.
Okay, yeah, maybe then. So how does a case get past this federal bouncer? What are the main ways in?
Well, there are basically 3 main paths to get federal SMJ. First up is federal question jurisdiction, FQJ.
FQJ. Sounds official.
It is. This happens when the plaintiff's claim itself arises under federal law. So we're talking U.S. Constitution, federal statutes, federal treaties. The claim has to be based on federal law.
Okay, so if I'm suing because my boss violated federal anti-discrimination laws, that sounds like FQJ.
Precisely. But here's the catch, and this is huge for the MBE. Remember the well-pleaded complaint rule?
Yes, the rule designed purely to cause pain.
Pretty much. It means the federal issue, the basis for the FQJ, it has to be right there on the face of the plaintiff's initial complaint. It can't be something the defendant might bring up later.
So it's got to be the main plot, not some potential plot twist defense.
Exactly. The feds only care if the story starts with a federal issue.
Yeah.
So suing over a contract breach, a state law thing, but the defendant says, oh, but a federal regulation excuses me. That defense doesn't count for FQJ.
Got it. The plaintiff's story dictates. Are there any automatic ins for FQJ, like slam dunk federal cases?
Yes, definitely. Things like admiralty, maritime law, so shipwrecks and pirates, basically.
Swashbuckling lawsuits, love it.
And intellectual property is another big one. Copyright, patent, trademark stuff. If someone's ripping off your invention or your brand, that's federal court territory.
Okay, so if someone's selling really bad knockoffs of my, designer dog sweaters online, federal court.
You got it. Messing with intellectual property, that's a federal issue. All right, so that's FQJ. What's the second way into Club Fed?
Let me guess. It involves people from different places hating each other.
Close. It's diversity jurisdiction, DJ. And this one's got a 2-part test. You need both.
Always with the tests. Okay, lay it on me.
First, you need complete diversity of citizenship.
Complete. Sounds absolute.
It is. It means no plaintiff can be a citizen of the same state as any defendant. Think of it like legal cooties. Nobody on the plaintiff's side can have state citizenship cooties with anyone on the defendant's side.
Okay, so plaintiff from Cali sues defendant from Arizona and defendant from Nevada. We're good.
Good.
Plaintiff from Cali sues defendant from Arizona and defendant from Cali.
Nope. Game over. Diversity is destroyed. Complete diversity means complete separation by state citizenship between the two sides.
Got it. No cooties allowed. What's part 2 of the diversity test?
Part 2 is the amount in controversy. The claim has to exceed $75,000.
Exceed. not just be $75,000.
Correct. That's a classic MBE tripwire. $75,000 and 1 cent. You're in.
Yeah.
Exactly $75,000. Sorry, stay in state court has to be over the threshold.
Over 75K. Okay.
Yeah.
So how do we figure out this whole citizen of the state thing? It's not just where you'd like pay rent, is it?
For individuals, for actual humans, it's about their domicile. Domicile takes two things. One, you have to be physically present in the state. And two, you need the intent to remain there indefinitely.
Indefinitely. So not just there for school or a temporary job if you plan on leaving.
Exactly. It's your true home, your principal establishment, where you plan to stay.
Okay. Makes sense.
Yeah.
What about corporations? Those soulless legal entities, where are they citizens? Delaware, usually.
Well, often incorporated there, yes. But for diversity purposes, a corporation is actually a citizen of two places.
Complicated.
It's a citizen of the state where it's incorporated, and it's a citizen of the state where it has its principal place of business.
Principal place of business. Okay, is that like the main factory or the fanciest office?
Nope. The Supreme Court gave us the nerve center test for this. It's where the corporation's high-level officers direct, control, and coordinate the company's activities. Think of it as the corporate brain.
The brain. Okay, so a company could be incorporated in Delaware, have factories everywhere, but if the CEO and the bigwigs making decisions are all in, say, Las Vegas.
Then Vegas is likely its principal place of business, its nerve center, and it would be a citizen of both Delaware and Nevada for diversity purposes.
Double citizenship, double the chance of messing up complete diversity.
Yeah.
Got it. Okay, so FQJ DJ, is there like a backdoor into federal court? A +1 situation.
There is. That's supplemental jurisdiction. Section 1367, if you're nasty.
Ooh, statutory.
This lets a federal court hear claims that don't have their own FQJ or DJ if they're so related to a claim in the same case that does have federal jurisdiction that they form part of the same common nucleus of operative fact.
Common nucleus of operative fact. Sounds fancy. So basically, if the claims all arise from the same incident or transaction.
Exactly. Same underlying facts, same event. If you have a solid federal claim, say FQJ, the court can also hear your related state law claims against the same defendant from the same incident, even if those state claims alone wouldn't meet the diversity requirements.
Okay, so the federal claim gets the state claim in as its +1, basically. He's with me.
Good analogy, but big but here, especially in diversity cases. Supplemental jurisdiction cannot be used by a plaintiff to bring in a claim against a party if doing so would destroy complete diversity.
Ah, so the +1 can't bring their own annoying cousin if that cousin is from the same state as the plaintiff.
Precisely. The diversity rules still gatekeep, even with supplemental jurisdiction in play for plaintiffs adding claims against certain parties. You got to protect that complete diversity.
Keeping the cooties out. What if the main federal claim, the one that got everyone into the party, gets dismissed? Does the state law claim get kicked out automatically?
Not necessarily. The court has discretion. It can decline to exercise supplemental jurisdiction if the anchor federal claim drops out early, but it doesn't have to. It'll weigh things like, judicial economy, fairness, where the case is procedurally.
Okay, judicial discretion. Fun times. All right, so that's S&J the what? Federal question, diversity, supplemental. Now, let's shift gears. Let's talk about who the court can actually push around. Personal jurisdiction, PJ.
Exactly. SMJ is about the type of case. PJ is about the court's power over the actual parties, specifically the defendant. Can this court in this state exercise authority over this specific defendant? It's the who.
Right. Can a court in Alaska tell someone sunbathing in Miami what to do? Probably need a good reason. What are the classic ways courts get this power, this PJ?
Well, there are the traditional bases, the old school ways. First one is presence, or tagging.
Tagging, like playground rules, but with lawsuits.
Kind of. If the defendant is physically present in the forum state, even just temporarily, and they get served with the lawsuit papers right then and there, boom, tag, you're it. The court likely has PJ.
Just got to catch him inside the state lines. Are there ways to mess this up? Like, can I lure someone into the state under false pretenses just to serve them?
No, that's generally a no-go. If presence is secured through fraud or force, or if the defendant is only in the state to participate in a different court case, then tagging them might not work for PJ. No trickery allowed.
Okay, no legal ambushes. Fair enough. What's another traditional base?
Domicile. We talked about this for diversity. If the defendant is domiciled in the forum state, lives there with intent to remain indefinitely, then that state's courts have general personal jurisdiction over them.
General. Meaning?
Meaning they can be sued there for anything, regardless of where the lawsuit's claim actually arose. Your home state can pretty much always haul you into court.
Okay, home is where the lawsuit is. Makes sense. What else? Is there a way to just agree to it?
Yep. Consent is the third traditional basis. Defendants can consent to PJ. Sometimes they do it in advance, like in a contract with a forum selection clause saying all disputes will be litigated in state X.
The fine print.
Or they can consent by their actions in the lawsuit. Like if you show up and start arguing the merits of the case without immediately objecting to personal jurisdiction, you might have waived your objection. You've consented by participating.
Silence is consent sometimes. Or rather, failing to object is consent.
In a way, yes. You have to raise that PJ defense early, or you lose it. And of course, plaintiffs consent to jurisdiction just by filing the lawsuit in that court.
Okay, so tagging, domicile, consent, those are the classics. But things got more complicated, didn't they, thanks to some shoes?
International Shoe v. Washington, the landmark case. It set the modern constitutional standard for PJ, especially when those traditional bases don't apply. It's rooted in the due process clause.
Due process, fairness, basically.
Right. International Shoe says that for a state court to have PJ over an out-of-state defendant, that defendant must have certain minimum contacts with the forum state, such that maintaining the lawsuit there does not offend traditional notions of fair play and substantial justice.
Minimum contacts. Okay, sounds kind of vague, like a bad dating profile. Seeking defendant with minimum contacts. What does it actually mean?
It boils down to this concept of purposeful availment. Has the defendant intentionally reached out and conducted activities within the forum state? Have they taken advantage of the benefits and protections of that state's laws?
So they had to, like, swipe right on the state, intentionally engage with it.
Pretty much. It can't be just accidental or random contact. Did they sell goods there, solicit business, sign a contract, perform there, drive on its roads and cause an accident? It's about intentional interaction. Just knowing your product might end up somewhere isn't usually enough. You need to have targeted the state somehow.
Okay, so my online store selling those questionable taxidermy squirrels, if I actively market and ship them to people in Wyoming, I've probably purposefully availed myself of Wyoming.
Likely, yes. You've reached into Wyoming to do business. Now, once you have those minimum contacts, we need to look at relatedness. This leads to two types of PJ under the modern test: specific and general.
Specific versus general. Okay, break it down.
Specific jurisdiction is where the lawsuit arises out of or relates to the defendant's specific contacts with the forum state. There's a direct link. The contacts cause the lawsuit, essentially.
So, using my exploding Wyoming squirrel example, if a squirrel I sold to someone in Wyoming explodes and injures them, and that sale is my only contact with Wyoming, Wyoming would have specific jurisdiction over me for that specific squirrel lawsuit.
Exactly. The lawsuit is directly connected to your contact sale with Wyoming.
Got it. So what's general jurisdiction under this modern standard? You mentioned it with domicile.
Right. General jurisdiction is way broader and much harder to get these days, especially for corporations. It means the defendant's contacts are so systematic and continuous that they are essentially at home in the forum state.
At home.
If a court has general jurisdiction, it can hear any case against that defendant, even if the case has nothing to do with their contacts in that state. For individuals, at home basically means their domicile.
And for corporations, is it still incorporation and principal place of business?
Yes. The Supreme Court has really tightened this. For corporations, being at home generally only means the state of incorporation and the state of the principal place of business, the nerve center. Just doing a lot of business in a state, even continuous business, usually isn't enough anymore to make a corporation at home there for general jurisdiction.
Wow. Okay, so that's a huge deal. General jurisdiction is rare for companies outside those two specific states. MBE alert right there.
Absolutely. Very high bar. Now, even if you find minimum contacts for specific jurisdiction, there's one more step: fairness.
The fair play and substantial justice part.
Right. The court has to weigh several factors to see if exercising jurisdiction would actually be fair and reasonable. Things like the burden on the defendant to travel and litigate there, the state's interest in the case, the plaintiff's interest in getting relief there, the efficiency of the court system.
Yeah, high factors if you need a mnemonic. Burden, state interest, plaintiff interest, interstate interest.
Yeah.
Something like that.
Something like that. Basically, is it fundamentally fair to drag this defendant into this court for this lawsuit, even if they technically have minimum contacts? Usually, if contacts are strong, fairness is presumed, but it's a potential out if it's super unreasonable.
Okay. So PJ, traditional basis, tag, domicile, consent, or the shoe test, minimum contacts plus fairness. Contacts mean purposeful availment leading to specific related claims, or general, at home, rare for core, jurisdiction. Phew. One more piece. Venue.
Last piece of the puzzle, venue. This isn't about whether the court has power, that's SMJ and PJ. It's about where geographically the case should be heard within a court system that does have jurisdiction.
So we know we're in federal court, SMJ. We know the court has power over the defendant, PJ. Venue asks, which federal courthouse is the right one, like the Southern District of New York or the Eastern District?
Exactly. Choosing the right neighborhood within the right city, basically. And there are rules for this in federal court.
Got to be rules. What are they?
Right. Okay, the general federal venue statute says venue is proper in pari. First, a judicial district where any defendant resides if all defendants reside in the same state.
Okay, so if I sue 3 people and they all live in California but in different districts, LA, San Diego, San Fran, I can pick any of those 3 districts.
Correct, as long as they're all residents of California.
What if they live in different states? Or what's the next option?
The second main option is a judicial district where a substantial part of the events or omissions giving rise to the claim occurred, or where a substantial part of the property that's the subject of the action is situated.
Okay, the action spot. This could be more than one place, right?
Oh, definitely. Think of a contract negotiated in one district, signed in another, breached in a third. Venue might be proper in any of those places where a substantial part of the story happened, like that bad road trip venue could be where it started or where the car broke down.
Got it. What if neither of those work? Like the defendants live all over the place and the events happened overseas.
Then there's a fallback rule. If there's no district where venue is proper under the first 2 options, then venue is proper in any judicial district where any defendant is subject to the court's personal jurisdiction with respect to such action.
We got to sue them somewhere rule. Last resort.
Pretty much.
How does this residence thing work for corporations when it comes to venue? Same as diversity.
It's a bit different for venue. For venue purposes, a corporation is deemed to reside in any judicial district where it's subject to personal jurisdiction for that specific lawsuit.
Any district where it has PJ, so potentially lots of places.
Potentially, yes. If it's a state with multiple districts, it resides in any district within that state where its contacts would be sufficient for PJ if that district were its own state. Or if no such district exists, then the district where it has the most significant contacts. It's a bit complex, but basically corporations can reside in multiple districts for venue purposes.
More places to sue them. Lucky ducks. Now, critical point, especially for the MBE, I bet.
Yeah.
Venue isn't based on where the plaintiff lives, right?
Huge point. Generally, no. The plaintiff's residence doesn't determine proper venue. It's focused on the defendants and where the events occurred. You don't automatically get home court advantage just because you're the one suing.
Good to remember. Avoid that trap. Okay, last thing on venue. What if you file in the wrong place? Or just a really inconvenient place, even if it's technically proper?
If venue is improper, the court can dismiss the case, or, more likely, if it's in the interest of justice, it can transfer the case to a federal district where venue is proper.
Okay, transfer, not just toss out.
Right. And even if venue is proper where you filed, the court can still transfer the case to another proper venue if it's more convenient for the parties and witnesses and in the interest of justice. Think about where the evidence is, where the witnesses are.
So they can move it somewhere that makes more sense, even if your first choice was technically okay.
Exactly. And there's also a related concept called forum nonconvenience, which is mostly used when the really more appropriate court is in a different country. The U.S. court might dismiss the case so it can be brought in that foreign court instead.
Okay, got it. Transfer for convenience within the U.S. system. Dismissal for forum nonconvenience if the better court is international.
You've nailed the basics.
Ooh. Okay, future legal eagles. We have just wrestled with the beast. Subject matter jurisdiction, personal jurisdiction, and venue. Key takeaways. SMJ, what kind of case? Federal question or diversity, complete plus 75K. PJ, who can the court grab? Traditional bases or minimum contacts, purposeful availment plus fairness. Venue, where should the case be? Defendant's residence or where the action happened. Remember all that. Good. You have officially laid back, listened, and learned. Hopefully.
These are absolutely fundamental. They come up constantly on the MBE, often tangled together. Really understanding SMJ, PJ, and venue is crucial for navigating those Civ Pro questions.
Couldn't agree more. And speaking of navigation, Join us next time for Episode 2 of our Bar Prep and Chill Civil Procedure series. We'll be diving headfirst into the wonderful world of pleadings and motions. Oh, the joy.
Get ready for complaints, answers, Rule 12b-6. It'll be fun.
Funnish. We promise more attempts to make it bearable, maybe even, dare I say, slightly entertaining.
Yeah.
More legal breakdowns, more questionable analogies.
Looking forward to it. Keep studying, everyone.
Until then, keep hitting those flashcards. Try not to dream in procedural rules. And remember, you got this. Seriously. We'll get you next time on Bar Prep and Chill.